Thank you, Gerald, and thank you to the organizers for this kind invitation. I'm very happy to be here and speak with you about some of my thoughts on the longer term arc of machine learning. And this is a really longer term think piece, this paper. It examines the outermost boundaries of machine learning in law and in life more broadly. It attempts to answer some questions such as, are personalized laws and micro directives possible? If so, to what extent? How precise can machine judging become? More so than human judging? If yes, do the models become stale? How do we know they've become stale? When do they become stale? The same questions for machine lawyering and the decisions that lawyers make. And the paper's intended audience is pitched to lawyers and judges. So I apologize to the more empirically minded academics in the room and scholars in the room if some of my examples are more intuitive and easy to follow. So I think the real value of the paper is that when I lay out the limits of the boundaries of machine learning, I handle three important objections. And these objections I term the first being the infinite model, that is, all is computable. The second is the closed model, which is we can use legal rules or other types of rules to close the environment of what counts as computable, or what we look at for computing. And then the final criticism is the updating model, which I find the most interesting, and perhaps you will too. And this is the point that all is sufficiently computable. The motivation for the paper is, I believe that understanding these limits, these longer term broad arced limits, help us identify when and why, as I mentioned previously, precise models begin to generate substantial errors, and what we can do to avoid that and think about it intelligently. And also to abate concerns. These understanding the limits of machine learning, I think, would help abate concerns of a rising empiricism in law, a rising technical rationality in law, and the ascendance of machines over laws more traditionally human and intersubjective character more generally. And I want to take up this last point first. I do this in the paper by examining three 20th century thinkers in Europe. First is Heidegger, the second is Marcuse, and the third is Jürgen Habermas. So I'll start with Heidegger very briefly. In his paper, 1953 paper, so this is after he wrote Being in Time. This is a paper entitled On the Question Concerning Technology. Heidegger observes that technology aims at revealing everything. And this drive towards the complete or full revelation of all human life, of all information, according to Heidegger, this drive drives out other perspectives. And in the process, it blocks us from seeing deeper truths. Human activity that takes place with what he calls like a Stell, or this enframing, this perspective, this technological perspective of complete revelation, according to Heidegger, can never directly counter the danger of blocking us from seeing everything. And his solution is to become aware of this problem and then embrace other perspectives, that is, other perspectives other than technology and technical rationality. So for example, poetics or art. So this is an external critique of technology and technical rationality. So the paper observes that there's some problems with Heidegger's formulation in thinking that human innovation can never counter this problem. And what I point out is that dynamism and open environments and constant change of technology, they directly counter the ability of technology to reveal everything. So technology will continue to produce errors the more perfect we try to make it. I also point out that his solution is imperfect too, because as we've seen recently, this mystery making that Heidegger encouraged us to embrace with poetry or art can be delegated to machines. We now have AI artists, and we've now seen this in law, where a lot of the AI decision making and criticisms of it are because we don't understand why it is occurring. It's mysterious. Marcuse, instead, and this is a decade later, he's concerned with technology. He first observes that we deploy it as a means towards an end, and that end is human flourishing. And we attempt to use technology to eliminate labor and generate abundance. And in the process, we allow ourselves to be manipulated by our machines. And so Marcuse thinks that once we have machines doing all the hard work, and we live in a leisurely, non-competitive environment, then our own willful subjugation to technology will cease, and technology itself will become obsolete. This assumes, the critique that I raise in the paper is that Marcuse is assuming that machines can solve labor needs and scarce resources more generally. It also assumes that humans will not deploy technology for other competitive ends, even after labor disappears and we achieve full abundance. These assumptions obviously can be wrong. People will continue to compete even if machines are doing all the hard work. And more importantly, there's areas which I raise in the paper where machines perform poorly vis-a-vis humans, which means that they can never eliminate certain forms of labor. Finally, turning to Habermas, technology for Habermas is also a means to an end. And this end is the legitimization of political power. And he lays this out in an article in 1971, which is before his great work on the theory of communicative action, which he wrote a little bit later. And in this paper, he lays the groundwork for this theory of communicative action. And as he works through it, some of you may be familiar with it, so I won't go in detail here, but we can talk about it in the questions. But he works through his theory, and he says that intersubjectivity, so human deliberation, human consensus, dialogue, exchange, all of the ways that we rationalize and legitimate action through human interaction, this intersubjectivity, must be protected through a jealous guard of human language. And we must liberate human language from technological and empirical rationales. So empirical rationales for Habermas stand in contrast to human dialogue, human deliberation, and intersubjectivity. And the way to preserve human dialogue is through separating empirical rationales from more human-centered rationales. There's problems with this as well. The most obvious is that there's an assumption that the two can be separated cleanly. But more interestingly, I believe, is that Habermas is assuming that empirical rationales can eliminate intersubjective and human rationales completely. And I believe this is untrue. And the reason why is because intersubjectivity will continue to perpetuate through human creativity and dynamism. And these are areas where machines perform less capably. So let me move to this point, which I call the unmodeled world. There are limits to machine learning, and they're realized through, I think, at least three things. The first, which most of us are familiar with, small sample sizes, the reflexive behavior of human beings, more generally attributed to Lucas, and then finally innovation. And these three limits to machine learning, these outer edges or boundaries to machine learning, arise from Leslie Valiant's two conditions. He's a computer scientist. For those of you who may have read his 2013 book, probably approximately correct. He recently won the Turing Award. But these two conditions for machine learning to take place, according to Valiant, is that irregularity must be detectable, and that the environment or the context in which that regularity occurs must be sufficiently stable. The context must be sufficiently stable or invariant. So let me just tackle small sample sizes, reflexive behavior, and innovation very briefly, and then turn to my final three criticisms of this unmodeled world. And so lawyers uninitiated in computational law often believe small sample sizes can be solved with either more data collection effort or the accumulation of more observations as time continues to move forward. However, counterfactuals or unlabeled outcomes can never be observed. So for instance, we have the recidivist behavior of an incarcerated defendant, or a trademark confusion of an enjoined mark. Behavior and confusion are modeled by selecting features of what we can see and then matching those features to what we haven't seen, or the unlabeled outcome. And we're often interested in predicting these unlabeled outcomes. But if incarcerated prisoners or the uncirculated trademarks that could potentially lead to confusion are never circulated within the population, and they possess unique features, then the counterfactual of those unique features circulating in the environment is never observed. We solve for this today primarily by looking at some variation in what's allowed to circulate. So the Kleinberg paper in the Quarterly Journal of Economics, which received a lot of attention, looks at how some judges permit risky prisoners, or in my example, trademarks, to circulate, but other judges don't. And so what we're doing is we're suggesting that an algorithm says, well, this person shouldn't circulate, but the judge, we have a high-risk judge or a judge with a high-risk appetite who's allowing that person to circulate, or that trademark to circulate, even though the model would say no. And this essentially amounts to a risky experiment. But let's say that the risky experiment yields some information, and we incorporate that information into our algorithm, we refine it, we update it. Still, if the subset of unreleased prisoners or algorithms still possess unique characteristics, then again, this counterfactual is never observed. Of course, this isn't a problem if we're selecting the correct features for matching and for prediction. And this is essentially having a good theory. Small sample sizes can persist. Even if we have the perfect setup empirically, some areas in law and in life can be truly small, that Valiant's condition for an observable regularity fails. So the leading textbook published by MIT Press, Goodfellow's the textbook, cites state-of-the-art learning methods requiring 5,000 labeled examples per category to approximate human learning capability, 5 million to exceed it. But just take an example. I take Wisconsin 2011 because there was a big case that came out of Wisconsin, and the Loomis case around that time. Of all released prisoners in Wisconsin, only 2,379 had recidivated within 3 years. Several hundred, if you start thinking of subcategories and labels, only several hundred had committed a violent crime in their recidivist behavior. We can add the data from the other 49 states or from subsequent years after those 3 years. And this data, adding this data will be helpful because the defendant behavior is sufficiently consistent across space and across time. In other words, we've selected the correct features for prediction. We have a good theory of recidivist behavior. So I think it's easy to see that if the theory is bad, or again, if the behavior is inconsistent over time and space, then we won't be able to use the data from Florida or California or the other 49 states, or we won't be able to use the data from 2014 and beyond, and prediction will fail. Reflexive behavior, the second category of the unmodeled world, comes from the Lucas critique. So interventions based upon past behavior must account for future programmatic policy changes. And these policy interventions are going to generate future unobserved behavior. So what we do is, particularly economists, we use structural models. And structural models have done really well. Susan Athey was recently named president of the American Economics Association. She's certainly advanced the ability of structural models to model preference formation and do it quite well. And we've advanced our structural modeling capabilities with machine learning because we're learning about what features matter for building our model. But again, these models, these structural models will be susceptible, they are susceptible to variance to conditions for machine learning, and especially contextual invariance, I believe. So just a simple example suffices here. Increasing, say, a structural model tells us that increasing prison size by 1 cubic meter may cause a reduction in inmate violence by X%. And that model's built with data in 2018 and prior data to 2018. So we have a pandemic that arrives in 2019, which leads to some inmate social distancing on their own and potentially rendering our causal model obsolete. Finally, innovation. I'm almost done here. Behavioral and environmental shocks or unplanned innovation change and often expand the map of the probability space. So we map this probability space out into the future as it appears in the present. Of course, our map will improve as small sample sizes grow, as our structural models sharpen, but still these shocks will continually render parts of the map obsolete. It's human behavior, it's unplanned innovation. Okay, 3 criticisms. The infinite model essentially says this entire probability space can be mapped. The closed model says, well, we can section off irrelevant areas of the probability space, and we can safely ignore them and just focus on what we can see. And then finally, the updating model, which I find the most intriguing, is that the probability space can be sufficiently mapped and then updated as new data arrives. So the infinite model, this critique might say that, well, if we have all data, if we have unlimited computational power, we can compute every possible state on the map. This model assumes that it can see the full map, even though the map is in a permanent state of flux. I think it's obvious, but certainly not to all legal scholars. It should be obvious that this infinite model bypasses truly spontaneous behavior. It essentially says it's not important. The closed model, the unmodeled world of small sample sizes, reflexive behavior, and innovation is unimportant because we can close the full probability space to something manageable. We do this all the time in computer science. Candidate models are limited with hypothesis testing as a matter of course. We exclude the unlikely. We set boundaries on the map in order for our learning to sharpen and for better prediction to take place. In law, we do the same. Judges exclude evidence for expediency in addition to constitutional reasons. Lawmakers do the same. We only look at a certain set of facts in order to determine if somebody has violated some tort standard. Of course, personalized law promises to open this closed model up a little bit more and consider more things. And we hope, as understanding of law and of life grows, these closed models become better. But again, they will always be subject to error and disruption when Valiant's second condition of contextual invariance is imposed. So this leads us to the updating model. Law and machine learning will chart a course nonetheless. As data accumulates and patterns are detected, machines will take over. And then human innovation arrives, eliminates contextual invariance, behavior changes, and the models undergo updating again. So we can see this with a very easy example again. Take AlphaGo. It's obviously deployed in a closed environment. Patterns are detectable. We have the rules of the game, Go, strategies of the players, and then we have the context is stable. The size and the shape of the playing board. The AlphaGo rule or the Go rules are consistent over time. But let's say the rules change. Maybe a piece of piece movement change over time, or a new section of the board is added. Well, a human player will easily defeat AlphaGo until AlphaGo has a moment to retrain itself. So in some domains, law is more closed. Machine learning will easily ascend in those domains. In others, law is more open, and humans will remain central. So again, I'll just conclude by reiterating these two Valiant conditions of detectable regularity and contextual invariance. I think that these two conditions imply three hard limits for machine learning in law and in life generally. In some domains, these limits can be overcome, and perhaps easily, especially where behavior is fixed and environments are sufficiently stable, like the game of Go or chess. In others, where things are more open, these limits will persist because behavior and environments are subject to spontaneity, unplanned innovation. Attempts to close the probability space in these areas will be met with error. Therefore, fears of complete technological ascendance, as articulated by Heidegger, Marcuse, and Habermas, are exaggerated, though some interesting intermediate states should obtain. So thank you.
Thanks, Frank, for that very philosophical and very informative presentation. Does anyone have any responses, questions?
Yes, I have one.
Yes.
Yes.
Yes. Go ahead.
So this is Geras. So thank you so much, Frank, for the presentation. What I wanted to check is that in your overview of AI models, it seems that this kind of a research is based on taking the fact that the text of a legal matter is available as a string of UTF-8 characters, but the text matters are consisting of documents, and then they have another two dimensions. That is not only text, but these are other dimensions are layout and formatting. So of different, various documents, either statutes, legislation, matter documents, either in transactional law or dispute law. So my question is there any progress reported in machine learning of recovering the other two dimensions as they applied in AI? And those two dimensions are layout and formatting.
Sure. Yes, I would hope so. And there will be progress to the extent that legal scholars begin looking at the layout and formatting. This type of non-textual data can easily be observed and computed by a machine just as well as a human. And we can look for patterns in the layout and in the formatting, and see if those patterns, to see if first if they're detectable, and then second if they tell us anything interesting. Whether or not some work has been carried out in this area, I'm sure there's people in the room that know better than I do, but I know that computational legal scholars are surely looking at extra-textual information. I know of studies, for instance, in Michael Livermore's excellent book on law as data. There's a study by Dan Chen that actually looks at voice intonation of litigants in the courtroom. And that's not a document, but that's certainly, we can think of as extra-textual or beyond the text, right? So they're looking at raises in the pitch of the words being spoken to the judge. That's a type of format. And this actually does, Chen find, predict things. So yes, there's certainly room to begin looking for detectable patterns in extra-textual information, certainly.
Thank you so much.
Not a question, just a brief reaction, Frank. It was a pleasure to listen to you. I often find it difficult to follow like the philosophical part of the debate and don't see its immediate use. But I think this was, even for someone skeptical as I am, I had a good time. And I don't say that very lightly when it comes to these topics. So thank you very much.
I'm very happy to hear that. You know, my goal with the paper is to engage lawyers who are skeptical of empirical and computational approaches to law. And so, you know, I think it's important to look at what the philosophers and the political scientists and sociologists are saying, and to understand how they look at technology. And these three thinkers of Heidegger and Habermas in particular are quite paradigmatic of some of the skepticism of what Habermas would call a technical rationality or an empirical rationality, overtaking things like pure human consensus. So I think if you think of those types of thinkers as an external critique, Gerald, to computational law, I think when we look at our own internal critique, then we can link up with the external critique quite easily.
One quick thought on that, because I was thinking it's a smart move bringing in Habermas and Heidegger and all these very like large scale German sounding philosophical names. So I think I see what you're doing. I think you might want to look at Niklas Luhmann as well, because that tends to impress people on that side of the spectrum. And there's some very good connections that one could potentially like make in all seriousness. So if you're looking for another big name, I think he would do one.
Great, thank you.
Do you have any questions? There's one question for you, Frank, in the chat from Rochelle.
Okay.
Just read it out. Is there any research available on how to determine which legal fields will be simpler to apply machine learning to? I think you referred to the more closed fields as opposed to the fields that will continue to be problematic.
Yeah, unfortunately, there isn't much research on this question, and I think it's a very important question, and it's a rich topic to begin to explore. You know, areas that are settled, I would think, just for the first time, just thinking about it now, that we should expect that routine decision-making with fairly similar and stable sets of facts, say in administrative law, would do much better than, say, an appellate court that's looking at a question of first instance. So I might begin attacking this problem just by looking at the hierarchy of courts and understanding that closed legal domains would probably be more populous in lower courts and administrative courts, Whereas open legal domains, you'd find more cases of open domains in appellate and in higher courts. I know in my own work in commercial law, I've looked at the entire body of good faith contract law in the United States, and good faith is a standard, and it's relatively open. And I've compared that to other contractual law doctrines and other corporate law doctrines that are more closed. And so I think also thinking along the dimension of rules versus standards is another way to think about this question. Thank you.
And maybe a quick one, or maybe two small questions from me, if you don't mind, Frank. I think the first one is that also from reading your paper, I really appreciated the philosophical discussion. I think it was more accessible than actually most I've read in this area. What I had trouble following was how the front part, which is the philosophical part, kind of links towards the second part, where I think essentially you've used the two conditions from Valiant to evaluate like the closed versus the open world models. So that's one first question, like how the two parts gel together. And I think the second one is kind of a broader question, which is, so what's the takeaway that you would like people doing computational legal studies to come away with? Is it that basically the world should not be modeled or cannot be modeled, and so what do we do in response to that?
Sure.
Thank you.
Yeah, so the first question with regards to the linkage between the philosophy and sociology to the unmodeled world is that, again, I think it's easy to see in terms of an external critique versus an internal critique. So these three thinkers externally critique empirical rationale. They say that there's problems with the modeled world because it limits us in our ability to see certain things, Heidegger, or it subjects ourselves to machines and we lose a certain amount of freedom, Marcuse, or we lose a certain amount of human input into the political sphere, Habermas, right? So these are all external critiques of using technology and empirical rationales to make law and to govern ourselves. But all of them assume that technology can achieve and machine learning can achieve full learning. They assume the heights of technology. And I think if each of these thinkers were to fast forward into 2015 and come across some limits, or 2020 and come across some limits, that they might rethink their positions. So by seeing that there are limits to machine learning, then you become less fearful of its ascendance. So that would be the linkage, I think, is quite important. So by merging the external and internal critique, you develop more of a deeper understanding of the role of technology. It's not so much a means to an end as it is a process. The takeaway for the paper for computational legal scholars, for me, is that we really need to understand and develop the idea of the updating model. If we begin doing what they're doing in New York and developing these wonderfully precise models on deciding recidivism, well, we need to ask ourselves, well, when is that recidivist data going to be stale? Is it 10 years? Is it 20 years? Is it 30 years? And why? And so how often will our models require updating? And so take, for example, recidivism in particular. If we have a new technology, for example, like an ankle tracking bracelet, and we're able to see the movements of somebody who's released on bail, then clearly it's going to change our model of recidivism, because the person has a much lower probability, I would suspect, of recidivating if they're being tracked. So here we have a new innovation, a tracking device, which changes the model, and we can imagine other situations just as easily. And so to understand that we need to think about how often the training models, the training data needs to be updated, and how to think about the training data. Saul Levmore and I have a paper, for instance, on competing algorithms, and we talk about how the state should set up competitions. And we discuss in that paper that the competitions must maybe need to take place periodically, every 5 years, every 10 years, every 20 years. We don't know, in order to keep the model precise. So I think what I'm hoping by writing this provocative paper, which I think is provocative, is to help us begin thinking about the role of updates and how often these models need updated.